Hello everyone, my name is Denny May and I'm with Brenda and we are the due process consultants here at Kentucky Valley Educational Cooperative. Today's topic for our training is going to be manifestation determinations. Today's learning targets and goals will be to define manifestation determination and then to have a discussion of when to complete a manifestation determination. And then we'll identify the steps in the completion of a manifestation determination and identify sources of documentation necessary for completion of the process. So an overview of the manifestation determination history, this process was first included in the regulations for 1997 when IDEA was reauthorized, and then it was simplified in the IDEA 2004 reauthorization. And what it now says is it limits the requirement to perform a manifestation determination to removals that constitute a change of placement under IDEA's disciplinary procedures and does not require a manifestation determination for removals for less than 10 consecutive school days that do not constitute a change in placement. So in our attempt to define manifestation determination, we understand that the ARC must complete a process when they reach 11 days of removing the student from the placement. And manifestation is determining if the behavior the child is exhibiting is caused by the disability. Secondarily, we also have to be concerned with, are we implementing the IEP with fidelity? So when we look at the federal regulation, it states that a manifestation determination must be conducted within 10 days of the child reaching that 11th day removal. And this is because of a violation of a code of student conduct that we would start to look at that. So on this slide we have the Kentucky regulation that speaks to when a manifestation must be conducted. And it states that if an action is contemplated that will result in a change of placement of a child with a disability who has engaged in behavior that violated any rule or conduct of the LEA that applies to all children, no later than on the date on which the decision to take action was made, the parents shall be notified of the decision and given a copy of their procedural safeguards or parent rights. And then you have 10 school days after the date on which the decision to take the action is made to review the behaviors and for the ARC to look at the relationship between the child's disability and the behavior that's occurring.
Okay, we are now looking at the manifestation determination meeting notice. Most districts contact the parents or the legal guardians the day of the infraction. If the infraction is severe, the 24-hour notice is utilized. Others will have the 7-day notice. Remember, the parents can agree to have the meeting earlier. We must make sure that parents were given a copy of the procedural safeguards with that notice. All school districts have a special education policies and procedures manual available for you to review, and there should be an additional information the district may want completed that is not in this presentation. Now we were looking at who is involved. Remember, the school and the parent need to be in agreement to make this work. Everyone that knows about the infraction should be at the table. The link between the child's conduct violation and his or her disability is very important. So the purpose of the meeting is to determine if the conduct was caused by or had a direct relationship to the child's disability, or if the conduct was the direct result of the local education agency's failure to implement the IEP. The federal regulations tell us we must review all relevant information about the student. At the manifestation determination meeting, the students with disabilities, the policy and procedure manual states the manifestation must be conducted within 10 days of any decision to change the placement. Make certain the parents receive a copy of the procedural safeguards.
So IDEA recognizes that a child with a disability may display disruptive behaviors characteristic of the child's disability, and the child should not be punished for behaviors that are a result of the child's disability. Prior to the ARC meeting, the chairperson needs to discuss the situation with the teachers and staff that has information concerning the infraction. It may help making the right decision for the child. This is done prior to conducting the manifestation determination. It gives the chairperson an idea of the situation and how to go forward. The ARC members make the final decision. A disciplinary change of placement occurs if the removal is for more than 10 consecutive days, or the child has a series of removals that constitute a pattern. Now, these three bullets are going to tell you about the removals that constitute a pattern. A series of removals totaling more than 10 days in a school year, or students' behavior is substantially similar to the student's behavior in previous incidents that resulted in the series of removals, and additional factors such as the length of each removal, the total amount of time the student has been removed, and the proximity of the removals to one another. Remember, if a student has behavior issues, no matter what the disability is, we must address it. It is important to mention in the present levels, the special factors, and have goals and objectives that address the behavior. If the student's behavior impedes the child's learning or that of others, the ARC must consider the use of positive behavioral interventions and supports and other strategies to address the behavior.
We are now looking at the interim alternative educational setting, referred to as IAES, placement by the ARC. Many times a district will use the IAES for a student that is going through a due process hearing. The school district can make that decision based on IDEA regulation. One crucial point to remember, IDEA law requires the ARC team to make that decision about the services and educational setting that the student will be receiving in IAES. Some IAES have no special education teachers employed. In order for the student's IEP to be implemented, a special education teacher will have to implement it. We are now looking at the ARC considering placement in the IAES. The ARC members determine the appropriate services and settings when a disciplinary change of placement, including an IAES, is made. We will talk more on that a little later. Now we're looking at the factors to consider. The relationship between the child's behavior and disability is not the only factor to consider in a manifestation determination. A manifestation determination must also consider if the child's conduct was a direct result of the LEA's failure to implement the IEP. If such a finding is made, the regulations require the LEA to make immediate steps to remedy those deficiencies. This slide references a report from the United States House of Representatives. The House of Representatives want to ensure the manifestation determination analyzes the whole child and across all settings and time when determining if the conduct is a direct result of the disability. How does the ARC arrive at the decision that the behavior of the child exhibits is or is not a manifestation determination of the student's disability? Let's move on and say the group has met, reviewed all relevant information in the child's file, considered the child's conduct in light of his or her disability, considered the LEA's implementation of the IEP, and come to a determination. What happens if the determination is yes? There are two scenarios under which a manifestation determination would be yes. These are when you conduct was a manifestation of the child's disability or the direct result of the LEA's failure to implement the child's IEP. If either condition is met, the student's conduct must be determined to be a manifestation of his or her disability. In other words, the manifestation determination is yes, but it matters which of the two conditions was the basis for the determination of yes. If the group determines that the child's misconduct was a direct result of the LEA's failure to implement the child's IEP, The LEA must take immediate steps to remedy those deficiencies. If such a determination is made, the LEA has an affirmation obligation to take immediate steps to ensure that all services set forth in the child's IEP are provided, consistent with the child's needs as identified in the IEP. Unless the behavior involved one of the special circumstances, weapons, drugs, or serious bodily injury, the child would be returned to the placement from which he or she was removed as part of the disciplinary action. However, the parent and LEA can agree to a change of placement as part of the modification of the behavior intervention plan. Steps to arrive at a decision. Collect and consider relevant information regarding the incident or the incidents. Review relevant information already collected, and consider the guiding questions.
This slide details the information that we will need to collect following the incident. So you will collect information that includes interviews of the witnesses, gathering other evidence including police reports and video, evaluation data, observation information, all those types of things that will go into making the overall determination. After collecting the information, you will need to follow step 2, which is reviewing relevant information regarding the incidents. Now we have collected all the data and reviewed it. So what's the next step?
The next few slides will give us questions that will guide us through the process. We're looking at the IEP to determine if the goals, strategies, and placement for the child are appropriate. So the first question is saying, were the service goals, strategies, and placements identified in the IEP appropriate? We can write an IEP, but we must ensure all the components in the IEP are implemented. So when you're looking at question 2, if the items in the previous question were appropriate, were the components or requirements of the IEP provided and implemented as written in the IEP? There are disabilities that can impair the student's ability to comprehend the impact and consequences of their behavior. However, that does not mean because a student has a low IQ, they do not know what they are doing. Each case must be reviewed with that particular student in mind. So when you're looking at question number 3, did the disability impair the student's ability to comprehend the impact and consequences of his or her behavior? Question number 4. Did the student's ability impair his or her ability to control his or her behavior, the situation in question? Now that we know question 4, let's analyze them.
So we're going to analyze the 4 questions now. Now that we've gone through the questions, let's look to see what the ARC should consider. Was there a decrease in inappropriate behavior as a result of the IEP and placement, or was there an increase in socially acceptable replacement skills as a result of the IEP and placement? So here is the comparison, and we're looking to see if the outcome is yes or no, and then what we have to do in regards to those answers. If yes, the behavior is most likely not a manifestation of the child's disability, continue with the process. If the answer is no, the behavior is most likely a manifestation of the child's disability. The responsibility is the school, and no further discipline for an incident can occur. So now we're going to decide if the behavior will require a suspension of longer than 10 consecutive days, or it will result in a total for the current school year exceeding 10 school days. So on this slide, we see the process is pretty self-explanatory. If, in fact, the answer is yes, then we move on with the process. And if we find that the answer is no, that the IEP has not been implemented appropriately, then we look at our own policies and what we've got in place for the IEP, and we have to do some redirection on the IEP itself. So another question that arises is, did the disability impair the student's ability to comprehend the impact and consequences of his or her behavior? In other words, can they tell right from wrong? And so in doing this, we conduct an interview with the child, and we can communicate with that student and see if they can communicate the consequences of the behavior, and if he or she understands the adverse effect of the behavior on self and others. If not, we can, as the staff conducts these interviews, to determine their perspective as to whether the child understands the consequences of his or her actions and the adverse effect on the behavior of themselves and others. If the answer to this question is no, there is no manifestation. If the answer is yes, then there can be no suspension of the child. If the So in question 4, did the student's ability impair his or her behavior for the situation in question? So through interview and talking with staff and parents regarding the student's prior behavior, is there a pattern or similar behavior? If yes, the behavior is most likely a manifestation. If no, if there's no pattern, the behavior is most likely not a manifestation of the child's disability. If the answer to question 3 is no, there is no manifestation of the disability in the child's behavior, and the student is subject to the same discipline as any other non-disabled student. If the answer is yes, then there can be no suspension of the child.
Now, what are our next steps? If yes for conduct directly related to the disability, if a child's misconduct has been found to have a direct and substantial relationship to his or her disability, the IEP team will need to immediately conduct a functional behavior assessment of the child unless one has already been conducted. We are now looking at, according to the State HELP Committee, and HELP stands for Healthful, Ethical, Legal, Parental Committee. So when we're looking at that, we look at an FBA focuses on identifying the function or purpose behind a child's behavior. Typically, the process involves looking closely at a wide range of child-specific factors. Knowing why a child misbehaves is directly helpful to the IEP team in developing a behavior intervention plan that will reduce or eliminate the misbehavior. In addition to conducting a functional behavior assessment, if necessary, the IEP team must also write a behavior intervention plan for the student unless one has already been written. If the latter is the case, then the IEP team will need to review the plan and modify it as necessary to address the behavior. This slide is looking again at the IEP versus the behavior intervention plan. And when we summarize this, when the behavior is related to the child's disability, proper development of the child's IEP should include development of strategies, including positive behavior interventions, supports, and other strategies to address that behavior. When the behavior is determined to be a manifestation of a child's disability, but has not previously been addressed in the child's IEP, the IEP team must review and revise the child's IEP so that the child will receive services appropriate to his or her needs. Implementation of the behavioral strategies identified in the child's IEP, including strategies designed to correct behavior by imposing disciplinary consequences, is appropriate even if the behavior is a manifestation of the child's disability. So when we're looking at this slide, we're looking at behavior intervention plan. And nowhere in Kentucky law can you find behavior intervention plan or its definition. It came from the hearing officers from the state, and they wanted us to include that as part of the IEP. A behavior intervention plan can be used for the classroom and for extracurricular activities.
So what about placement? The child must be returned to the placement for which he or she was removed as part of the disciplinary action, with two exceptions. If the behavior infraction involves special circumstances, weapons, drugs, or serious bodily injury, or if the parents and the LEA agree to change the child's placement as part of the modification of the BIP. If either of these exceptions apply, then the child need not necessarily return to the same placement. Again, here you will see a summarization of the previous slides, and a manifestation determination of no means either that the child's behavior was not caused by or did not have a direct relationship or a substantial relationship to the child's disability, or the child's behavior was not the direct result of the LEA's failure to implement the IEP. In other words, we still have to provide the special education and related services regardless.
This slide talks about the amount of services for more than 10 days removed. And what I want to caution you about is the minimum 2 hours per week may not be enough instructional time for the student to comprehend the lesson. In our regs, it actually talks about 2 hours of instructional time for a regular education student. So we must think about the student with a disability and determine how long we need to have someone out to work with this child. So you make sure you do not get into that situation, especially if it goes to court. We have to look at each student individually when considering the amount of time for homebound students. This slide is talking about questions and concerns, and as Denny, Paul, and I said here, we have decided that we might want to make you mindful of a few things. So if a child has a pattern of office referrals, someone needs to be monitoring that. And if not, and when the child gets into these little picky things, and they're not really written down or documented anywhere, and then all of a sudden the child just knocks someone out, and then the principal says, hey, you're out of here, and we have none of that documented. So what will happen if that goes into court? We don't have that documentation to show that we did anything about the little picky behaviors. So we need to make sure that we do something about those, because if it does go to court, the district might as well write the check.